Good morning. My name is Tommy Johnson. I'm with the Portland Regional Chamber of Commerce. Welcome to Growth Basics for Business, a monthly breakfast seminar series which provides a forum to gain useful do-it-yourself workplace solutions and insightful, actionable tips. I want to thank Eaton Peabody for their continued support of this virtual event series for the entire season. I'd like to welcome you all to the second installment of Growth Basics for the calendar season of 2023-24. This 10-part season-long series runs from September through June. Today's topic, leave peeping, Maine's paid family and medical leave, is presented by Sarah Newell and Jack Bjorn from Eaton Peabody. With some pending updates to Maine's rules and regulations around paid leave, employers will need to know and be well-versed in some of these significant changes. This morning, we'll cover the details of the program eligibility, reasons individuals will be allowed to take paid leave, the law's application to large employers versus sole proprietors, and the law's impact on private plans and collective bargaining agreements. Now, like all Chamber virtual signature events, today's presentation is free and will be recorded and made available for free replay on the Chamber's website and YouTube page. To keep up to date on all the Chamber's news and events, please visit our website, portlandregion.com, check out the event page, and sign up for our weekly newsletter while you're there. Before we get to today's presentation, I'm proud to share that we're continuing the use of StreamYard for all of our virtual Chamber events. This platform provides many improved production elements that I think you'll be very happy to see. I'd also like to remind you that if you have questions for our presenters, please type them in the YouTube chat and they'll be conveyed to our presenters throughout the presentation. And we'll leave a little bit of time for more Q&A at the end as well. Now, at this point, I'd like to acknowledge our presenting sponsor of Growth Basics for Business, Eaton Peabody. For the past 6+ years, Eaton Peabody has been the presenting sponsor of this series, and they continue their support this season. I'd like to invite Marketing Manager Nate Levesque to say a few words.
Great. Thank you, Tommy. First of all, I want to thank the Portland Chamber for doing such a great job of putting these together and providing new and engaging content month after month. I also want to thank our presenters, Jack and Sarah, for joining us this morning. And lastly, whether this is your first Growth Basics or your 10th, I want to thank you all for taking the time to join us this morning. For those of you that may not be familiar with our firm, we are a full-service Maine-based law firm with nearly 50 attorneys serving Maine clients from offices in Augusta, Bangor, Ellsworth, and Portland. We assist companies of all sizes in a variety of industries, so whether you're an established financial institution or a small business just taking your first steps, we can help with all of your legal needs. To learn more about the services that we provide and the industries that we serve, please visit our website, eatonpeabody.com. Also, be sure to follow us on Facebook or LinkedIn to stay up to date with community events, legal updates, and future presentations. Thank you, and back to you, Tommy.
Thanks, Nate. And now I'd like to introduce our presenters. With us today are Sarah Newell, shareholder, and Jack Bjorn, associate, both from Eaton Peabody. Sarah represents employers in the private, nonprofit, and public sectors, and her practice is focused on labor and employment law. She assists clients with a broad range of issues, including wage and hour, sexual harassment, FMLA, employee discipline and discharge, discrimination, whistleblower, collective bargaining, contract administration, labor arbitration, and many other employment and labor issues. Jack is an associate with Eaton Peabody's Employee Benefits Practice Group based here in Portland, Maine. Prior to joining Eaton Peabody, Jack earned his JD from the University of New Hampshire School of Law in May of 2019, and as a member of the Daniel Webster Scholar Honors Program. While in school, Jack served as a judicial intern for the Honorable Gary Hicks of the New Hampshire Supreme Court, as well as a judicial intern in the U.S. District Court for the District of New Hampshire. With that said, take it away, folks.
Good morning, everybody. Thank you all for being with us this morning. Sorry for my bad leaf peeping pun. It seemed like a fit season for that. So if anybody's rolling their eyes this morning at that, you can blame me. So thank you again for joining us as we discuss the paid family and medical leave law and its application to Maine employers. Nate, if you want to go to the first slide. Perfect. Thank you. So on July 11th, as many of you know, Governor Mills signed into law the Maine state budget in 2023, Public Law Chapter 412, which included the creation of a paid family and medical leave program. I'll refer to as the program. Maine is the 13th state to enact such a program. And under the program, beginning in 2026, eligible workers in both the public and private sectors will be eligible to take up to 12 weeks of paid family and medical leave. With respect to program eligibility and benefits, the program will be administered by the Maine Department of Labor and shall be effective as of January 1, 2026. The program covers eligible employees of eligible employers, including private businesses, the state, municipalities, and tribal governments. The program will provide up to 12 weeks of paid leave in a benefit year, which may be taken intermittently in increments of not less than 8 hours or on a reduced schedule as agreed to by an employer and its employee. Importantly, the benefit year begins when the employee takes the leave, and an employee would be eligible for additional leave at the end of that benefit year. Except in cases of emergency, employees must give reasonable notice of their intent to use the leave, and the use of leave may not affect an employee's right to accrue vacation time, sick time, bonuses, advancement, seniority, length of service, credit, or other employee benefits, plans, or programs. Of note here, just as a good example, if somebody was to take leave where they knew that a family member was going to be out with a surgery for a month and they needed to take care of them, giving their employer reasonable leave, a couple weeks, a month, however long in advance you know about the surgery, to allow them to make accommodations for their other clients and employees is expected under the law. Importantly, use of the leave must be scheduled to prevent undue hardship on the employer as reasonably determined by the employer.
And so I'm going to pop in with a couple of practical things here as we're going through. Those of you who manage leave programs currently can tell, I think, from what Jack's presenting, some of this lines up very well with family medical leave. So the 12 weeks, the available use of intermittent leave in most cases, and some of it doesn't line up with family medical leave. So for example, although under a family medical leave program, you can administer your program under a rolling year, you can also do it under a calendar year. So if you're an employer who has a family medical leave policy that works on the calendar year, that's going to be a little bit different from this policy, from this program, and you may want to consider moving to a rolling year for FMLA. So these are all things that you're going to think about, particularly once we know more about how these leave programs are going to be administered.
And that brings up an important point as well, which I'll reiterate throughout the presentation. As much as we know about the law, there's also just as much that we don't know yet. And as I'll further explain, the Department of Labor is required to come up with rules on the program, which will hopefully provide answers to a lot of the remaining questions that people may have. Again, getting back
one
to,
of the sorry, Jack. One of the things that when I was here looking at this and hearing Jack talk, you just heard him say, you can't schedule the leave in a way that creates an undue hardship for the employer. We don't know how that will play out in the regulations, what that means, but there is no undue hardship provision under the Family Medical Leave Act. So you may be in a position where you could deny an employee paid leave, but not deny them unpaid family medical leave, which, from a practical standpoint, you would never do. So there are definitely ways this will interplay that we will learn more about as time goes on.
Definitely. Thanks, Sarah. Just getting back to the program eligibility and benefits, an individual may file an application for benefits no more than 60 days before the anticipated start date of leave and no more than 90 days after the start of the leave. The administrator may waive this 90-day filing deadline for good cause. So again, if an emergency came up where either you or a family member was out for medical reasons and you weren't able to get a hold of your employer because you were in the emergency room or something, or something that required a longer period of time, the administrator may waive that inability to let your employer know for good cause. The program will be funded by employer and employee premiums that will begin January 1, 2025. Notably, that is a year before benefits will begin in order to fund up the program. The premium payments may not be more than a combined 1% of wages. Employers with 15 or more employees may deduct up to 50% of the premium required for an employee from that employee's wages and shall remit 100% of the combined premium to the benefit fund. Employers with less than 50 employees may deduct up to 50% of the premium from that employee's wages and shall remit that amount from the fund. So again, combined 1% total. The employee is responsible for 50% of that, or 0.5% of their wages. And in larger employers, those employers will be required to remit the other 0.5% to the fund.
Yeah, and this is one of those areas where it surprised me when I saw the law, because a lot of times these laws will be applied only to employers of a certain size. And this law is applied to employers of all sizes, even those that are covered under the FMLA law, which Maine law covers employers of 15 or more, but has some financial implications. So this is going to be, it's definitely going to be something small employers who are not used to being covered by these types of benefit programs are going to have to look out for.
And speaking of small employers, self-employed individuals who elect coverage shall pay 50% of the premium required. Again, that's 0.5% of their overall wages. Beginning in 2028 and for each calendar year thereafter, the Maine Department of Labor will set the premium for the coming calendar year based on the percentage of employee wages at a rate necessary to maintain the benefits of the fund. So several years from now, once the program is in place and up and running, part of the program administration is that they will use an actuary to figure out exactly how much money is required to pay benefits and to pay the administration fees, and will determine the amount that should be remitted to the fund each year thereafter. Employers that fail to make required contributions will be assessed a penalty equal to 1% of its total annual payroll for each year that it fails to comply, in addition to amounts already owed, as well as the total amount of benefits paid to individuals for whom it failed to make premium payments. So this is a pretty substantial penalty, especially as employers grow in size. So it will be important to make sure that we're following all of the rules as already announced and as will be forthcoming in the rulemaking process. Benefit payments to individuals are not payable during the first 7 calendar days of leave, something of a waiting period, which is common in disability type plans already. But employees may use other employer provided sick, vacation, paid leave during those first 7 days the employee is absent from work. Covered employees are eligible to receive up to 90% of their average weekly wage that is equal to or less than 50% of the state average weekly wage, and up to 66% of their average weekly wage that is more than 50% of the state average weekly wage, which I know is a mouthful. That is how the law is written. Just to simplify things a little bit, this means that somebody who is earning in the ballpark of $72,000 a year would be eligible for the maximum weekly benefit, with amounts being reduced from there based on the total salary or wage that person gets each year. Notably, the max weekly benefit shall be the state average weekly wage, which is $1,103.71 as of July 1st of this year. The benefit amount shall be prorated if leave is taken on an intermittent or reduced leave schedule. The weekly benefit amount will be reduced by other government wages or wage replacement or benefits from an employer permanent disability policy or program. So again, if leave is only taken a couple days a week because somebody is caring for another sick relative a couple days a week, they would only get 2 of 7 days, or that smaller portion of the weekly benefit instead of the whole thing. An annual study by a qualified actuary will examine the claims experience and admin expenses and the target fund requirements each year. The admin cost for the program may not exceed 5% of the amount deposited in the benefits fund. Excuse me. And the administrator must publish a report each year regarding the total claims and benefits paid. So this report at the end of each year will break down the leave by types of leave taken, either medical or family, the types of claims, the cost of claims, all in a way to further assess the viability of the program and ways to improve the program and see where the money is flowing. For self-employed individuals, including independent contractors and sole proprietors, may elect to participate in the program and receive coverage for an initial period of not less than 3 years, with such election becoming effective on the date of filing written notice with the Maine Department of Labor, with a form provided by the Maine Department of Labor. Such individuals may withdraw from coverage within 30 days after the end of the 3-year period by filing written notice with the commissioner, and self-employed individuals that have elected coverage but have failed or refused to make premium payments for at least 2 quarters may be disqualified from receiving benefits. Here, importantly, just want to stress that 3-year period commitment. If you are a self-employed individual and you sign up for the program, you will be required to participate for 3 years, which means making those premium payments for 3 years. And you will want to note the penalties if you fail to do so. That being said, if you fail to make payments for whatever reason, and you kind of true up your premium payments to the fund, you will then be allowed to go back and participate in the program going forward. All right. So, excuse me, with respect to private plans, collective bargaining, and concurrent leave, an employer with an approved private plan, is not required to remit premiums to the fund. Employers with private plans may apply to the Maine Department of Labor for approval to meet its obligations under the law through a private plan. In order to be approved, a private plan must confer rights, protections, and benefits substantially equivalent to those provided to employees under the program. So this would be the types of benefits and the amounts of benefits. So if you have a short-term disability program, for example, which would only provide benefits for your medical issues, that wouldn't necessarily cover all of the benefits that would be required under the family portion of this rule. And if you had it's easy to use a short-term disability program, but if that program provided a maximum weekly benefit that was significantly less than the amount provided under this program, then it's likely that would not confer benefits that are substantially equivalent to those provided under this program.
Yeah, so this is one area I think will develop quite a bit between now and when this law comes into play, because insurance companies' the products that we're currently using now for short-term disability probably will not meet these requirements. Some of us may also be self-insured for short-term disability. And we'll have to make sure that our plans match those requirements. Now, I think from a dollar standpoint, a lot of employers who self-insure will be above and beyond where we are, which is another issue that I think will come up, is that I think employers will find that some of the benefits under the plan are not as good as the benefits that we're currently providing employees, which will be a little bit of a tricky situation to try to roll that back if we're going to be required to participate in this program as well. So I think all of that is up in the air, and when we get closer to the law going into effect, that is going to be a time where employers really have to sit down and think about what their goals are for these types of plans, and where they want to go with them. But I do think you need more information before you're able to do that. One thing that employers could do now, though, is some form of data collection. They could start paying attention to what they are using in terms of paying medical leaves, how that's working, how many of their employees are taking advantage of those sorts of programs, and just to have a baseline of data so that you can evaluate this when we kind of know where all the chips are going to fall.
And that brings up a really good point too, Sarah, in that, as we approach the implementation date of this program, employers will have to choose whether or not they keep their programs or maybe they opt for this. But importantly, if the employer has a richer program, that's not necessarily a bad thing, and will be something that employers could advertise or use to attract employees, which is ever more important, as we know, in this day and age. So employers offering private plans that violate the private plan requirements will be subject to a fine of $100 per violation. The Maine Department of Labor shall also annually determine the admin costs arising out of the administration of private plans, which shall be reimbursed by said private plan. So even though a large employer with a private plan may elect to use its own private plan and give notice to the Maine Department of Labor that it plans to do so and follows all those requirements, the costs associated with administering that plan from the state's perspective, and in terms of knowing that plan applies to those employees of that employer, shall be paid from that employer. So there's still a little cost associated with the state of that private plan. The establishment of the program does not eliminate an employer's obligations to comply with any employer policy, law, or collective bargaining agreement that provides for greater or additional rights than those provided under the program. The program may not curtail rights provided under a CBA or employment contract. The program does not prevent an employer from compelling an employee to exhaust any rights to sick, vacation, or personal time prior to or while taking leave under the program. Importantly, I want to distinguish here that an employer, that only applies from what we understand to general employees and not those subject to CBAs. It is unclear at this point in time whether employees will be allowed to take PTO at the same time as PFMLA type benefits. But I would suspect that as the rulemaking process begins, that the state will clarify that point and probably follow Massachusetts' example, which says that paid family medical leave benefits and PTO or other vacation time may not be taken concurrently as to provide a double benefit, but those benefits could be taken during the same week, even if they couldn't be taken during the same day. So leave taken under the program, notably, shall also run concurrently with the federal FMLA.
And that's going to be important for employers to remember. It's always confusing to employers, but FMLA, federal and state FMLA, are always run concurrently with any type of payment program. So you just have to think of it as one program is the leave and one program is the payment of the leave, and they always run together, whether it's comp and FMLA or this type of leave and FMLA. That causes confusion for folks. The other thing that I'll say for anybody who's on the line who is a unionized employer who has a collective bargaining agreement, this may present some issues for you just based on what Jack just presented. You may want to, and as you know, collective bargaining agreements generally run for a 3-year period, sometimes shorter, sometimes a little longer under the federal law, they can't run longer than 3 years under the state law. So, you may want to include some language in your current negotiations for contracts that will be in effect when this law takes place. But that language would have to be broad and basically say that the parties agree the employer is going to comply with the law and may make changes. You know, a union doesn't love to have sort of these open-ended abilities to make changes. So you may want to be thinking of whether there are specific changes you want to propose during the collective bargaining process, or whether you need some sort of catch-all or reopener to deal with those issues. Or, you know, you can just go forward and see where the chips fall. You certainly can't have a collective bargaining agreement that doesn't comply with the law, but as Jack pointed out, you could have one that confers greater benefits.
And it will be important, you know, as the implementation date fast approaches, that if you have CBAs that are expiring between now and then, that you at the very least consider this new law and the benefits that it provides. Just as a note, and I think Sarah, this is a good question for you. Frank Kolovic in the comments has asked, just so I understand, your firm is offering what services with respect to the FMLA, program guidance and legal services for anyone who may be issued fines. I think certainly at this point we can provide as much guidance as we know in terms of setting yourselves up for future benefits implementation. Sarah is the expert on CBA negotiations and the like, so I will let her comment on that as well.
Yeah, so I mean, the services our firm offers are in general, both Jack and my practices tend to be very advice-based. I wouldn't advise at this point that you need to engage a lawyer necessarily to deal with this issue, although there are times, so for example, when you're doing your employee handbooks or things like that, sometimes you want to get those reviewed by a lawyer, and Jack or I might flag, well, remember this is coming up, and those sorts of things. As you get closer, certainly we could provide advice on implementation of the program, whether your how your current programs sort of mesh with the law once we know the regulations. And yes, I often provide advice to employers on collective bargaining. If not, I also perform I'm the chief negotiator for several clients for collective bargaining. So yeah, we provide all those. With regard to fines and whether, yes, we certainly help employers when they come to us with issues with fines or things like that. So we provide any of that guidance. You could reach out to either one of us if you needed assistance as this goes on.
And as we get closer to, I think it'll be clearer the kind of checklist of things that you need to run through as an employer to make sure that you are compliant with all the rules. And that includes things such as notice provisions and proper documentation to have on file to give to the employee or to have the employee give to you. Those types of organization measures that will be important to make sure that you aren't susceptible to the fines, and just making sure you're covering all of your bases. So with respect to reasons for taking leave, there are plenty of reasons that are prescribed under the law. And just a brief summary of those reasons include to bond with a covered individual's child or adopted child during the first 12 months after the child's birth or adoption. Again, just an important point to remember that the leave may be taken intermittently. So if you wanted to take 4 weeks after the birth of a child right away, and then take 8 weeks at the end of the year, then under this law, you would be allowed to do so. Other reasons include to take care of a family member with a serious health condition. Family member, notably, is defined quite broadly. It includes siblings, parents, and grandparents. So that will be something we'll pay particular attention to as we get a little closer to the implementation of the program as well. Reasons also include to attend a qualifying exigency, to care for a family member who is a covered military service member, to take safe leave as a result of violent sexual assault or stalking. And those types of leave could include both for yourself and for taking care of somebody who is taking safe leave, helping them get legal assistance, helping them find a safe place to live, all broadly defined under the statute. Reasons also include for taking personal medical leave for a serious health condition that makes the individual unable to work, and includes inpatient type services or ongoing medical care from a medical provider. Also includes to donate an organ for a human organ transplant, for leave following the death of a family member, and for other reasons as prescribed by law.
So looking through those reasons, some of them are consistent with the FMLA and some of them are not. So that's another area that employers are going to have to look at, where when we talk about FMLA and this type of leave running concurrently, it won't always have FMLA running. For example, most of the time under the FMLA, taking safe leave as a result of violence, sexual assault, or stalking would not be an FMLA qualifying reason unless it involved another health condition along with it. The other thing is, right, currently employers aren't required to allow intermittent leave for leave following the birth of a child. So I'm not sure how that will work itself out. I mean, the thing is, from a practical standpoint, if they're able to take that leave in that manner under this law, you're going to want to run it as FMLA anyway. So these are just things that employers are going to have to be aware of when they're administering the programs together.
Definitely. And certainly something that I think the future rulemaking will provide some additional guidance on as well. With respect to notice and return to work, employers must provide notice of benefits available under the program in a conspicuous place at each of its locations, and shall provide written info about the program within 30 days of the start of an employee's employment. So this will look like the other notices that you might post on a bulletin board in the cafeteria or break room or something, so that employees are made aware of the benefits of the program. Employers that fail to comply with the notice provisions will be subject to a civil penalty of $50 per employee for a first violation and $150 per employee for each subsequent violation. So again, something that could be a substantial fine. Just of note, as a bit of an aside, these fines will be submitted to the fund and will then thereafter be used to pay for the benefits and admin fees of the fund as well. Employers must allow employees that take paid family medical leave benefits to return to work in the position held by the employee when leave is commenced, or to an equivalent position with equivalent benefits, pay, and other terms and conditions of employment. Employers may not retaliate against employees for exercising their rights to benefits under the program. With respect to additional guidance and rulemaking, the law requires that the Maine Department of Labor publish detailed guidance and regulations. Such guidance and regulations must be published no later than January 1 of 2025. The program's administrator shall also establish reasonable procedures and forms for filing claims for benefits, and shall specify the supporting documentation necessary to support any claim for benefits. Notably, the rulemaking process has yet to begin, as far as I'm aware. By law, it's mandated to begin at the start of this coming year. Just as a summary of the important dates, this October, this month, the state budget goes into effect. Again, the paid family medical leave rules were enacted as part of the state budget back in May. In January of 2024, the Maine Department of Labor will begin its rulemaking process. On January 1 of 2025, the initial program rules will be adopted. At that same time, employer and employee contributions to the program begin. And in May of 2026, the claims for benefits will begin being processed. So with that, are there any additional questions? I am not seeing any in the comments, but that doesn't mean there haven't been some that come in some other fashion.
So while we're waiting to see if anything comes in through the comments, I'll just make a couple of other comments on this. I do think employers are going to see a lot more on this, so don't panic right now. If you're thinking, oh my gosh, I don't know how to do this or administer this, there's more to come. We do see there are several states that have enacted laws like this prior to now, and frankly, we have seen problems with these programs being administered. So I do think there could be bumps in the road as this goes on. I think employers will find, in Massachusetts, I know one of the big problems has been delay in payment of benefits, which will be difficult for employees, and particularly employees. So I anticipate I'll probably be getting calls from employers saying, can we put together a loan for this employee, or can we do this to sort of bridge the gap for them? Because, I think the legislature thinks they have to pass laws like this because we're all terrible to our employees and don't pay them while they're out on leave. But a lot of employers do provide pay while employees are out on leave and do these sorts of things. So I do think it may be bumpy as we get started, but hopefully it will, we'll be able to get the information that we need and things will work out better than they have in certain other states when they've sort of rolled these programs out.
Yeah, definitely. Certainly, there'll be some bumps in the road, as there are with any state-administered program. But as others may have seen on the video with respect to Maine's new IRA program that's set to begin soon, Maine has joined and learned from other states in that process. But that's for a different day and a different discussion. There are a couple of comments that have come in. The first is from TPD Portland, Maine. I may have missed this piece, but how do the premium payments work? So just as a brief summary about those premium payments, for larger employers, those with 15 or more employees, employers will be required to submit 0.5% of the employee's wages to the fund, and those employees will be required to submit 0.5% of their wages to the fund, for a total of 1%. And for employers with less than 15 employees, the employees are required to submit 0.5% of their wages, but the employers are not. There's a specific equation with respect to the benefits that are paid out, which, without quoting directly, I wouldn't want to mess up, but it all relates back to the state average weekly wage, and a portion of that state average weekly wage up to a maximum of $1,100 and change per week, based on that state average weekly wage as of July of this past year.
And from a practical standpoint, those premium payments then will be made from the state to the employee. The employee, and we don't know exactly how that will work yet because we haven't seen the regulations, but there will be some sort of application process for the employee to apply to use the benefits, and then the benefits will be remitted directly to the employee.
And we don't really know how quickly they'll be required to pay the
Right.
employees as well, which could create its own headache. But just on that note too, as we explained with the waiting period, the 7-day waiting period, employees will be allowed to use their other, paid time off, sick time, vacation time in that waiting period. And hopefully there won't be too much longer before benefits are actually paid out. out, but I would assume that PTO could also be used for any additional days needed to cover expenses as well. Nate Moody also asks, what kind of employee documentation is required to prove whether their leave reason is a qualifying reason, which is a great question, something that has not been decided yet. I think we will get more information in the rulemaking process. But for medical leave type benefits, that might include your doctor's note type materials to let an employer know that you either are in the hospital or are receiving ongoing care from a medical provider.
Yeah, and just for your benefit, for employers' benefit, I don't think this is going to change anything with regard to what we can still ask for from employees to qualify them for FMLA. So you're still going to use the FMLA forms from your side. We don't know what the state's going to require to prove that you're eligible for benefits.
Amy Talk has also added a comment. Is the number of employees the exact number of all employees or FTEs, full-time employees? We only have 7 full-time employees, but quite a number of very part-time workers. Another great question, something that hasn't specifically been fleshed out in the rules. I will say that we have had other similar questions posed to us with respect to seasonal workers. Based on what we already know and my own suspicions on the rule, this will be based on just total number of employees, whether or not they're full-time or part-time. And my guess is that it will be number of employees throughout the year. So if you have 15 or more employees in any year, whether that's a calendar year or otherwise, that you would be responsible as an employer to remit those premium payments. And if you have fewer than 15 employees, then you would not, as an employer, be responsible for your own portion of those benefits. Here in the example where we only have 7 full-time employees, but quite a few part-time workers, if the combined number of heads is over 15, then I would think, as the rulemaking process will let us know in the future, that you would be required as an employer to submit 0.5% as well. That seems to do it right now for the comments. Of course, if anything else comes in, we will be sure to address that, but we have wrapped up pretty close to right on time. Tommy, do you want to take it away for a few minutes? And if anything else comes in, we can address that.
Absolutely. And Jack and Sarah, thank you again. Great presentation. I know there's a lot of content here. So again, I like to always remind people that this will be captured, obviously, as a recording. And certainly if you have further questions, we can field those from you. But I want to say thanks again for another great presentation. And of course, thanks to the Chamber staff for helping to produce another successful event. At this time, I'd like to introduce Eamon Dundon, our Chamber Director of Advocacy, to provide some additional information and insight.
Thank you, Tommy. And yeah, first of all, just to echo that, thanks to Jack and Sarah for their very thorough overview of this complex and far-reaching law. And a final thanks to you for attending today. I know there was a lot of information covered, and you might continue to have questions that come up in the weeks and months ahead. We are more than happy to hear from you and follow up on those questions. I think Riley will put my email up on the screen there. Yeah, just on the bottom there. So please feel free to reach out to me at any time with any follow-up questions you might have or comments. This version of paid family medical leave was not our first choice as a chamber, and we actively pursued alternative paths in the legislature. But unfortunately, our calls and the calls of many in the business community went unheeded by the legislature and the governor. And so this is the version of the law we are now working with and educating our members about. And so finally, I know there's a lot we know about the law that was covered today, but also obviously many remaining questions that will be ironed out in the Department of Labor's rulemaking process and potentially a cleanup bill in the legislature in next year's session. We will be tracking both of those processes very closely. And so if you'd like to be updated on future changes and clarifications in advance of 2025, please use the QR code on the screen to subscribe to our advocacy updates. Those come via email if you're not already subscribed, and we will continue to update people as those processes unfold. So with that, I will hand it back to Tommy. And again, please reach out if you have any additional questions or comments.
Thank you, Eamon. And thank you again. You mentioned Riley. Riley is the person who produces all these events. And thank you to each of you for attending today and throughout the year. If you are interested in learning more about this topic, be sure to check your email for a follow-up message with links to some additional resources. Another shout out to our sponsors at Eaton Peabody for their support of the Growth Basics for Business series throughout this entire year. We look forward to seeing you again on November 14th when we plan to hear a presentation from Julio Trujillo on the topic of diversity, equity, inclusion, and belonging in the workplace. The Eaton Peabody Growth Basics for Business series is typically held on the third Tuesday of each month. So with that, have a wonderful rest of your day, get outside and enjoy fall.